Analysis of Waqf Amendment Bill 2024, Part 2. Those who style themselves as sole representative of Muslim community are partly responsible for this narrative that the entire fault lies in the law. They never raised the question of non-implementation of the Act 1995 by the states. In their national and international Waqf conferences organized with rich funding, non-implementation of the Act did not ever come up. Their discussions circled around deficiency in the law. Unaware of the revenue system of various regions, many of their suggestions for amendments were imaginary. Most of those who suggested amendments did not have field experience. They also promoted the narrative at a large scale that corruption in Waqf, in which Muslims themselves are involved, is the root cause. All this led to conclusion that law needs to be tightened to get rid of corruption. This narrative has become handy for the government. The bill on the same lines proposes to make changes in the Act to strengthen the Waqf administration. It did not stop here. When the Parliament referred the bill to JPC, a new narrative was circulated saying, "Of course, there are problems in the bill, which JPC will examine, but the bill has some good points also." Surprisingly, some self-styled Muslim leaders also started saying this. The first video of this kind I watched was of a Hakim doctor. I am still searching for anything good in the bill. I'll be grateful if it is pointed out to me. Among the matters related to Islamic fiqh, only Waqf has been codified with a single common act, unifying various sects and schools of fiqh. Historically, UP and Bihar have separate Shia and Sunni Waqf boards. They have been retained due to certain reasons. In all these other states, Waqf is being managed by a single united board in which various sects are represented. Effort should be made to retain this unity. The proposed amendment is an attempt to sharpen the Maslaki divide in the community. If leaders of some small sects are demanding separate board, history will teach them a lesson. After independence, the Waqf Act 1954 was enacted with the purpose of better administration and supervision of Waqf. Keeping in view the varying conditions in the state, the Act was not notified at once in all the states. Their own laws were allowed to continue. This was in consonance with the federal structure of the country. Despite the Act 1954 being comprehensive, difficulties surfaced in its actual working. It was examined and with full justification, the Act was amended thrice, namely Waqf Amendment Act 1959, the Waqf Amendment Act 1964 and the Waqf Amendment Act 1969. Unlike the present bill, those amendments were based on field experience and problems arising in its implementation. For example, during the discussion in the Rajya Sabha on Waqf Amendment Bill 1969, the members demanded constitution of a committee. Accordingly, Waqf Inquiry Committee was constituted on 9 December 1970 for the purpose of evaluating the Waqf Act 1954 and for making an inquiry into the administration of Waqf at all levels in respect of estates to which provisions of the Act 1954 were applicable. After mammoth exercise, the committee submitted an interim report in November 1973 and final report in February 1976. The committee made number of recommendations which envisaged restructure of Waqf administration to improve the financial position of Waqf and to plug the loopholes noticed on the working of the Waqf Act 1954. Based on the recommendations of the Waqf Inquiry Committee, amendments were made in 1984. However, members of the Muslim community strongly opposed various provisions of the amending act, which made the amendment controversial. Therefore, after a wide range of consultation and careful examination of objections, the Waqf Act 1995 was enacted. As mentioned earlier, the Act has not been implemented, which is the main cause of problem in the administration of Waqf. Without the study of that, the present bill has been introduced. Again, during the discussion on calling attention in the Rajya Sabha on 9th September 1996, the government agreed to constitute a House committee to look into the matter. The committee thus constituted in the Rajya Sabha was later on converted into Joint Parliamentary Committee of both the houses on 8th January 1997. With extensions and recommendations, the committee functioned till 31st December 2008 and prepared 9 reports. Out of that, the 3rd and 9th reports dealt with amendments in the Waqf Act 1995. On the basis of those reports, Waqf Amendment Act 2013 was passed. The JPC, during their visits to various states to evaluate the working of board, had observed that one of the main reasons for the ineffective functioning of some of the boards was lack of resources and institutional capacity. The present level of assistance provided by the state governments is not only inadequate but also uneven. Accordingly, the JPC in its 9th report had recommended that the state Waqf boards should be given central financial assistance. Although it was not pointed out by the JPC that the lack of institutional capacity is also because the state governments in many states do not allow filling in the sanctioned posts. Are the Muslims responsible, as has been stated time and again by the self-styled community leaders and now being propagated by those who want the bill to be passed? मुसलमान खुद ही खराबियों के लिए जिम्मेदार हैं is the general rhetoric. It requires to be rejected. No, it is the government which has taken responsibility of superintendence of Waqf. It constituted Waqf boards for the purpose and failed in capacity building. A close look on the Waqf Amendment Bill 2024 reveals amazing facts. The statement of objects and reasons of the bill has failed to justify the proposed amendments in the Waqf Act 1995. It has simply said, quote, despite the amendment, that is 2013, it has been observed that the Act still requires further improvement to effectively address the issue related to the powers of the state Waqf boards, registration and survey of Waqf properties, removal of encroachments, including the definition of Waqf itself. Quote ends. It has not been clarified if this reservation is based on some survey or the finding of some study done after 2013 on the working of Waqf. On what basis it has been determined that the stated ineffectiveness is due to the strong shortcoming in the law and not because of non-implementation of the Act itself. If the law has not been able to effectively address the issues, the justification could have been provided section-wise in the proposed amendment. After Section 3 of the Principal Act, the bill proposes to insert 3B, which says, quote, every Waqf registered under this Act prior to the commencement of the Waqf Amendment Act 2024 shall file the details of the Waqf and the property dedicated to the Waqf on the portal and database within a period of 6 months from the commencement. Quote close. Moreover, without providing any reason, collectors are proposed to be armed with wide-ranging powers. The collector may become both prosecutor and judge. This may tighten the government's control on Waqf, but as history tells us, will not be effective. As detailed earlier, this move is in a democratic setup has its parallel in the company era, but not even in the British era. Here it is necessary to understand the background of the bill to place it in proper political perspective. It all began in 2015. The low-rent tenants of Waqf refused to accept annual increase in the rent in Delhi, Haryana and Punjab. They were joined by the Waqf land encroachers. They approached the central government. Lease rules were amended twice. Simultaneously, a general rhetoric that mutawallis are corrupt and boards are den of corruption was circulated in social media, creating impression that the corruption is the root cause of mismanagement in Waqf. Not only those who close to the ruling party, but also others aspiring to be Muslim leader joined the rhetoric without ascertaining the facts. This was suitable to the powerful lobby which always eyed on the priceless Waqf land in metropolis. Before introduction of the bill 2024, one more propaganda with falsification of facts was launched, mostly in social media, that the Waqf boards have powers to declare any property as Waqf property. Appeal against that can be filed only in the Waqf tribunal, which decides the dispute on the basis of Sharia law. It was also propagated that the decision of the tribunal is final, against which no appeal can be made in any court. Impression in public mind was created that tribunals are Muslim institutions. This was to scare the public in general. The genesis lies in the uncalled for assertion on Sharia in Waqf matters. Waqf is the only subject in the religious matters of Muslims which has been fully codified. The codified law passed by the parliament is accepted by the Muslims without any reservation related to Sharia. In my 15 years of experience as Secretary Central Waqf Council, we did not have to seek fatwa in any matter. The Islamic scholars are there in the board and the council to keep an eye. For the last time, council sought the opinion of prominent madrasa about unused graveyard was in early 1980s. In future also, if required, board or council may seek their fatwa or opinion. Sharia has been taken care of in the codified law. Repeated speeches and papers on Sharia in every conference diverts attention from the key issues. It creates an impression that in Waqf matters, decisions are taken on the basis of Sharia and not on the basis of law. This is happening in Muslim education also, which can be discussed on some other occasion. Tribunals neither have exclusively Muslim members nor are their decisions based on Sharia. One can always appeal in the High Court. Provision of the Section 83(9) clearly states, quote, provided that the High Court may on its own motion or on the application of board or any other person aggrieved call for and examine the records relating to any dispute, question or whether the matter or other matter which has been determined by the tribunal for the purpose of satisfying itself as to the correctness, legal or propriety of such determination and may confirm, reverse or modify such determination or pass such other order as it may think fit. Quote close. The propaganda is just to justify the bill. This is creating frenzy. The propaganda is continuing with the capacity to reach lakhs of people within minutes. This gives clue to the purpose of for which narrative related to Waqf has been developed in public sphere. The propaganda was also launched that the government of India and railways, Waqf board was the biggest landowner. This gave an impression that if Waqf boards have so much land, it is by declaring any property as Waqf property. Public did not know that much more land is owned by the mandirs. Jagannath Temple of Puri in Odisha alone is the owner of 60,000 plus acres of land. Total land owned by the temples is much more than the Waqf land. Land owned by the mandirs is also under encroachment. 974 cases of Jagannath Temple alone are pending in different courts. This should be brought to the knowledge of those who curse mutawallis. Now all those in support of the Waqf bill are propagating to justify the proposed collector Raj for Waqf. This rhetoric diverts attention from the basic issue regarding the absence of mechanism for the implementation of the act for which states and central government are solely responsible. A law cannot give the desired result if proper mechanism for implementation and supervision is not in place. While introducing the bill, tall claims were made. One of them was giving representation to women. In the case of Central Waqf Council, the proviso of the Section 9 of the Waqf Act 1995 is already there, saying, quote, that at least 2 of the members appointed under subsection 1 to 8 shall be women. Similarly, Section 14(1) on the composition of State Waqf Board says quote, provided further that at least 2 members appointed on the board shall be women. Quotation close. Both in the composition of council and board, provision has been made for at least one membership of professional such as town planning, business management, finance, revenue also. Of course, one innovation in this bill is the membership of non-Muslim in the council and the board. The benefit of this has not been stated in the bill. The hidden agenda is clear. Can they dare to do it in the case of other religious endowments? Waqf is on the concurrent list. It is not known if the draft bill was sent to the estates for their assent or not.